Good evening, everyone. I'm Chris Ames, the president of Russell Sage College, and I'm delighted to welcome you to the Social, Ethical, and Legal Implications of Senate Bill 8, program sponsored by the Women's Institute at Russell Sage. The Women's Institute has committed to programming and action that's related to the effects of crises on women. Our focus on refugee issues and support reflects that, as have our programs on the effects of the pandemic on women. When we developed that area of emphasis, we anticipated issues like these, as well as climate change, but the framework has also allowed us to devote attention to the current crisis in reproductive rights and freedom. Thus, this program with these extremely well-qualified guests. I assume that most of our listeners, and surely all our students here, are younger than I am. Increasingly, that's a fair assumption when I go places. But if that's so, it's likely that you've lived your entire life in America where a woman's right to choose to terminate a pregnancy or not is protected as a constitutional right. We're approaching the 50th anniversary of Roe v. Wade. And I think it's both appropriate and sad to see Texas at the heart of this battle. I grew up in Austin, and when I think about my own political education and development, there are things I recall. I remember being excited at age 15 when the constitutional amendment passed to allow people to vote at 18. I turned 16 the year Roe v. Wade passed. And 3 years later, I cast my first vote in an election, not just for President Jimmy Carter, but also for my local representative, Sarah Weddington, who had argued the case of Roe v. Wade in front of the Supreme Court and who passed away just last month. Now, nearly a half century later from that landmark decision, we're experiencing the most serious challenges in a long time to women's reproductive freedom. So I look forward to the discussion that's going to follow. I think it's really important, and I thank all of you for attending. It's now my pleasure to introduce Shelley Calabrese, who's Executive Director of the Women's Institute. Thank you all for being here.
Thank you, President Ames, and good evening, everyone. Thank you for joining us for tonight's panel discussion, the social, ethical, and legal implications of Senate Bill 8. Senate Bill 8, also known as SB 8 or the Texas Abortion Law, was signed into law by Texas Governor Greg Abbott on May 19, 2021. The self-dubbed Heartbeat Act barred abortions once cardiac activity has been detected within an embryo, which typically occurs within the 6th week of pregnancy, sooner than many women realize they're pregnant. The bill also made no exceptions for pregnancies resulting from rape or incest. While similar restrictions have appeared in proposed anti-abortion legislation, what commanded greater attention was SB 8's unusual empowerment of private citizens rather than law enforcement to sue any individual who performs or aids and abets an abortion outside of the 6-week limit, recovering their legal fees and a minimum of $10,000 from the defendant should they succeed. By removing the involvement of state officials from the bill, this stipulation has restricted the legal recourse of abortion providers who would ordinarily have sued the state to keep such a law from taking effect. The law, which came into effect on September 1st, 2021, garnered widespread praise and condemnation, respectively, from anti-abortion and pro-choice groups. Particular outrage has been generated by SB 8's alleged violation of the 14th Amendment of the Constitution, which guarantees a right to privacy that has long been interpreted as protecting a pregnant woman's liberty to choose whether or not to have an abortion. On December 10th, 2021, the Supreme Court declined again to block SB 8, but ruled that Texas abortion providers could challenge the law in a lower court. With further challenges to Roe v. Wade set to be heard by the Supreme Court in 2022, it's anybody's guess how abortion rights may soon be shaped in the US. With us here tonight to talk about SB 8 is a scholar activist within international and national women's health and reproductive justice movements, a feminist bioethicist specializing in reproductive and sexual ethics, and a legal expert whose scholarly work is focused on reproductive ethics. Our moderator, Benita Zahn, is a certified health and wellness coach, working with clients at Capital Cardiology Associates. She earned her master's and doctorate in bioethics at the Alden March Bioethics Institute at Albany Medical College, and spent more than 40 years as a health reporter and news anchor at WNYT in Albany, New York. Before I turn things over to Benita, I want to remind everyone that tonight's event is designed as an academic dialogue in SB8, and we welcome and encourage lively and respectful discourse. If you have questions for the panelists, please post them in the tab marked Q&A on your screen, and feel free to submit questions as you think of them, and we'll get to as many as possible in the time allotted. And now, Benita, over to you.
Shelley, thanks so very much. It's a pleasure to join all of you this evening for this very important discussion, and one I'm sure that you will all find enlightening. And as Shelley pointed out, there will be plenty of time for Q&A, and I will be happy to moderate that and make sure that as many of your questions are answered as possible. I'm having an interesting technical night, so if you're seeing me from two different perspectives, that's technology, but we're going to forge on, because what's important is the essence of the conversation that we will be treated to this evening. Our first guest tonight is Claire Horner. She is an assistant professor at Baylor College of Medicine and a clinical ethicist at Baylor St. Luke's Medical Center. She earned her JD and MA from the University of Pittsburgh and completed a clinical ethics fellowship at the Alden March Bioethics Institute, my alma mater. Her scholarly work is focused on legal and ethical issues in reproductive ethics, particularly issues that are arising in gestational surrogacy, contractual agreements in reproduction, and Catholic bioethics. It's my pleasure to welcome Claire. The screen is yours, Claire.
Thank you so much, Benita, and thank you to Shelley and Sage Women's Institute for having me. I'm very excited to talk today about Senate Bill 11. Being in Houston, this has certainly been something that has been in the news, a very big part of the news down here. And I've had a lot of conversations about this with many of my colleagues, so I'm very excited to be part of this today. I want to talk today about the legal implications and the clinical implications of this Senate Bill 8. As Shelley has already talked about, this bill is essentially a 6-week abortion ban. It prohibits abortion after the detection of cardiac activity, which can happen as early as 6 weeks of pregnancy, which really means 4 weeks after fertilization, so 6 weeks from the last menstrual period. You can see here an actual picture from a blogger who posted her barely visible positive pregnancy test at 6 weeks. So many women don't even know that they are pregnant at that point when this 6-week ban is in place. The law itself is enforced by private citizens, meaning that anybody can sue a person who aids or abets a woman in getting an abortion. This means that the woman herself who gets the abortion will not be prosecuted, but anybody else who helps her, from the physician to the surgical tech to, I apologize, my cat has entered the chat here, to the surgical tech, to people are wondering if maybe even the Uber driver could be involved. Anyone who helps or encourages a woman to get an abortion after this 6-week ban is liable under this law. The penalty is $10,000 plus attorney's fees. It really is a powerful penalty, especially if it's against an individual rather than a clinic or an institution. And what's interesting is that there don't seem to be any recourse for, if it's a frivolous lawsuit. Typically in frivolous lawsuits or lawsuits where there's really no basis for information, the person who's defending can get some attorney's fees back, and that's not possible. Really, this is completely on the side of the person who is suing on behalf of essentially the private citizens for somebody undergoing an abortion. There is one exception written into the law. As was mentioned earlier, it's not rape or incest, it's medical emergency. So the actual definition in the abortion law of medical emergency is a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that, as certified by a physician, places the woman in danger of death or a serious risk of substantial impairment of a major bodily function unless an abortion is performed. So this means that for this law, a woman can have an abortion after 6 weeks after the the detection of cardiac activity only if a medical emergency exists. Now, I'm going to come back to this a little bit later because this is really one of the most important parts of this law that really calls into question whether or not it even makes sense from a pro-life perspective. Again, I'll get to that in a few minutes. What's important about this law is not just that it is so unique in that it is not about state action, but it's about private action, that private individuals are suing on behalf of themselves rather than the state. But that this really implicates something called the shadow docket. This case, when when the law was first filed, several institutions filed a lawsuit against Texas, asking for it to be overturned, essentially saying this is unconstitutional. This is a blatant violation of longstanding constitutional and Supreme Court precedent that women cannot be and individuals providing lawful abortions cannot be penalized. And this lawsuit was filed in the district court, in the federal courts in Texas, and eventually went up to the Supreme Court. The hope was that the Supreme Court would stop the law from going into effect before September 1st. As many of you are probably aware, the Supreme Court came down right before the law was to take into effect. I believe it was at night, saying we will not block the law. And further discussion with the Supreme Court decided to say, look, you cannot, essentially what they were doing was trying to sue the state agencies and to sue the Attorney General and others who were the county clerks who might be filing these lawsuits, to sue them to say that you can't force them, they can't file these lawsuits. That is unconstitutional to file these lawsuits, essentially preventing these lawsuits from going into the courts in the first place. And the Supreme Court said, no, we're not going to allow that. And it sent it down to the Fifth Circuit, which is, again, part of the federal court. The Fifth Circuit has since sent it down to the Texas Supreme Court. It went back to the state law, back to the state courts. And the reason why this is important is because there's a thought that if it stayed in the federal courts, there was a chance that the federal courts would find that this law was unconstitutional. But now that it's back in the state court system, it's really kind of pessimistic whether or not this law will be overturned or determined to be unconstitutional. So this shadow docket is something that we know that the Supreme Court issues their major rulings in about 60 to 70 cases per term. They have at least 2 full rounds of briefing on a case. Oral arguments are held in public at a date and time that's fixed months in advance. And the court comes out with lengthy written opinions that are handed down and actually read in a carefully orchestrated tradition. We know what these opinions are. We know what each justice said about this case. We know who was in favor and who was opposed. And we know their reasoning, most importantly. But in the shadow docket, we don't know any of those things. This docket is really meant for emergency relief from the court. It was meant to sidestep the formal appeals process for really emergent issues. The applicant must prove that they will suffer irreparable harm if their request is not immediately granted, which allows the Supreme Court to hear cases on an expedited basis and to be able to give answers very quickly. Again, really for emergencies only. So just to give you a sense of the history of the shadow docket, between 2001 and 2017, only 8 of these applications for emergency relief were filed by the Department of Justice. After that, the Trump administration filed 41 of these applications in just 4 years. So this shadow docket has really grown considerably in the last few years, as has the type of case that the Supreme Court has been handling as well. So rather than really emergency criteria of emergency relief applications, making sure that a law doesn't go into effect before arguments can be had to determine whether it's appropriate, the court has actually started resolving more politically charged disputes, not just SB 8, this issue of abortion, but also disputes over the border wall, COVID-19 safety restrictions, and federal executions. So we see the shadow docket becoming more and more important, and yet still more and more opaque. So as I mentioned, for arguments on the merits in the Supreme Court, there are 2 full rounds of briefing. It's a very transparent process. But rulings on the shadow docket come usually only after one round of briefing, and sometimes even less than that. Usually are accompanied by no reasoning at all, let alone a majority opinion. It may be a one-sentence decision. There's no identification of how the justices voted or how many of the justices voted. And it can be handed down anytime, day or night. So a decision might come out in the middle of the night and nobody might notice until sometime later. So we see the shadow docket really having a huge impact on not just individuals who are fighting for these emergency petitions, but also for constitutional rights that have much broader implications. So let's get back to the current legal status of SB 8. Currently, the major lawsuit is called Whole Women's Health v. Jackson. This is the case that I talked to you about just a minute ago. This is the one that went up to the Supreme Court. And ultimately, the ruling was that Whole Women's Health and the other plaintiffs cannot sue state judges, the attorney general, or the court clerks to prevent them from filing or continuing with these lawsuits against abortion providers. However, they left it open to say that you could sue perhaps licensing agencies. So for example, the Texas Hospital Association. Really what this means is they can't stop anybody from doing this because the licensing organizations really have no relevance to this law. But that is essentially where the case stands now. And now it's currently in the Texas Supreme Court, still unresolved. There's another case out there, Braid versus Stilley. And this is a case where an abortion provider in San Antonio wrote a public op-ed after this law was put into effect, stating that he had performed an abortion on a woman because it was necessary. And because of this, there were 3 plaintiffs that came out of the woodwork and filed suit against Dr. Braid under this law. These were consolidated, and currently the case is still ongoing. It's really in its early stages. And one of the questions was whether the 3 plaintiffs could each get $10,000 or if you could only have one penalty of $10,000. But essentially what happened is you can have a plaintiff who has no interest in the case, doesn't know any of the parties whatsoever, and really just wants the $10,000. And that's what happened in this case, is these individuals come forward and they take the opportunity to get some easy money, and they sue people who are involved with providing abortions. So with all of that, SB 8 is still an active law, which means there are many implications that have already happened since September 1st. The clinical implications of this law are very vast, and you'll see this image on the left from the Guttmacher Institute. These statistics are if there is a total ban on abortion. If Roe v. Wade is overturned and there is a total ban on abortion, you can see these statistics. But as of now, where we have the 6-week ban, the vast majority of abortions have been stopped. More than 40% of women don't even know they're pregnant until after 6 weeks. One of the biggest things that has changed is before this law went into effect, the average one-way driving distance to an abortion clinic was 17 miles. Now the average one-way driving distance is 247 miles. And because of Texas law, there is a 2-visit minimum because 24 hours have to go by between the first visit, in which the woman is required to be provided with an ultrasound and a description of the embryo or fetus, and when the abortion can actually be performed. And the abortion actually has to be performed by the same clinician who does that initial exam. So you can understand how burdensome this actually has been for women. And not only are women traveling to states around Texas, but they're traveling farther out as well. They're going to states as far as Montana or New York to try to receive abortions. Many of the clinics have also closed. Certainly many clinics provide abortions far past 6 weeks. And so many clinics have been forced to close because they can't stay open if they can't provide additional care. There have been many other impacts as well. I told you I would return back to this question of medical emergency. What does medical emergency mean? Well, it has to impact a woman's life or a severe bodily function. What happens if a woman is pregnant and she discovers that she has cancer and she needs cancer treatment immediately. What if she could potentially wait until the pregnancy comes to term and then she could deliver and then she could start her cancer treatment, but her chances of survival go down? Does it matter whether her chances of survival go down to 10% or 20%? What if it's 60%? Is that too high to be considered a medical emergency? It's unclear. Is this woman required to carry her pregnancy to term, even if it means that she'll have to forego cancer treatment or delay cancer treatment, or if she wants to remain pregnant and receive cancer treatment, that the fetus could perhaps have severe anomalies because of the teratogenic cancer treatment? What about a woman who is in severe heart failure, congestive heart failure, who cannot carry a pregnancy because it is exacerbating her heart failure? If she could perhaps survive the pregnancy, is that really a medical emergency? Does having to delay putting her on the transplant list for a heart considered a medical emergency, or a risk that she has to take because it's not severe enough? Pulmonary hypertension is another common scenario in which a woman may need to deliver immediately. Now, this is more likely to be a medical emergency because typically we see that a woman will die without a termination in early pregnancy if it is severe enough. But again, all of these situations call into question whether or not medical emergency encompasses the many conditions in which a woman may want or desire a termination of pregnancy so that she can receive treatment for other conditions. Another major impact is the fear of lawsuits. Physicians are afraid. They're afraid of being sued, and rightly so, with malpractice insurance premiums being so high. This law does not provide legal immunity. Unlike other laws, for example, the Texas Advanced Directives Act is the famous 10-day rule law, where physicians, if they don't believe that continued life-sustaining treatment is appropriate, can engage in a legal process in which they let the family know that they're not going to continue the life-sustaining treatment. There is a legal process there. And if they follow that legal process, there is legal immunity, meaning that they cannot be sued. That's not the case in this law. This provides a defense. It doesn't provide immunity, meaning that the physician who provides the abortion can be sued no matter how emergent the case actually was. It can be a clear-cut case of medical emergency, and that physician can still be sued and would have to then bring up the defense of medical emergency, which means that the physician still gets sued. The physician still has to hire a lawyer and argue this defense. And again, anyone involved is liable. Any of the nurses, any of the surgical techs, any of the family members. I had a question come up about whether the ethicist who weighs in on whether or not this was appropriate could be liable under this SB 8 law. There's just so much fear and unknown that nobody really knows whether or not this is acceptable under the law. The biggest issue that I think is happening that we're not talking about, we know the impacts to abortion. We know the impacts to abortion clinics and those who are seeking abortions, but especially in the clinic, where the architects of this law, I don't think really realize the full impact of it, is that physicians, when they have a case of a woman who needs cancer treatment, would normally do the pregnancy termination and begin cancer treatment immediately. But now what's happening is they're taking a pause and saying, I don't know if this is okay. Is it legal for me to do this? Who do I need to talk to? I need to talk to my legal counsel. I need to call ethics. I need to talk to risk management. I'm not really sure if I'm allowed to do this. And so women are being denied care, being denied the standard of care, and care is being delayed because physicians and hospital administrators don't actually know how this law is supposed to be implemented. They don't know what their legal liability is. So even beyond the purpose of the law, which is to stop abortions, in these cases in which the architects of the law purported to carve out an exception for when a woman's life or health is in danger, it is actually still causing harm to women. And it raises the question of whether or not in these lawsuits, lawyers will essentially be cross-examining the cancer survivor or her surviving spouse about just how emergent her abortion was. Was it really that critical that you had the abortion and you didn't take it to term so that you could receive your cancer treatment? So again, I think it raises the question of whether or not this law, which is intended to be a pro-life law, is really pro-life. There are a lot of goals that the pro-life community has in stopping abortion altogether. And yet there is a recognition that even in the pro-life community, there are times in which pregnancies cannot be continued. And even this law goes against what pro-life individuals talk about as being pro-life, because it is harming women and it is preventing the standard of care from being provided. I know we'll have a lot more to discuss in the questions, and I look forward to my colleagues and their talks as well. But I thank you very much, and I look forward to our discussion.
Thank you very much for that detailed, thoughtful presentation, and so very edifying, I think, for folks who may have had questions as to the ramifications of this. So thank you very much, and I'm sure the questions will be forthcoming. Now it's my pleasure to introduce Dr. Lisacampo Engelstein. She is the director for the Institute for Bioethics and Health Humanities, Harris L. Kempner Chair in the Humanities in Medicine, and Associate Professor of Preventive Medicine and Population Health at the University of Texas Medical Branch. Lisa is a feminist bioethicist specializing in reproductive ethics and sexual ethics. In October of 2019, the BBC recognized her research as engendering a better future for women, naming her as one of the 100 inspiring and influential women of 2019. And it is my pleasure to introduce her and see her again, having spent some time and had an opportunity to interview her. And here in the Capital Region, you may have in fact heard her speak. Dr. Campo Engelstein, the screen is yours.
Thank you so much, Vanita, and thank you to everyone at SAGE for putting together this event, and to my esteemed colleagues on the panel. I'm really glad we're having this conversation. I know there are strong feelings, but I'm glad we're all here together. So what I'm going to do today is talk about some of the unique ethical features of SB8, because we've all heard conversations about the ethics of abortion, but I want to hone in here really on some of the features that my colleague Claire has already gotten to. And then I want to focus on how language shapes the abortion debate, and in particular, how language can grant fetuses personhood, and how this bill is another example of enhancing the moral status of fetuses to grant them rights that most adults have. Okay, so let's start with the ethical considerations here. As Claire spoke about, there is this 6-week limit, which is really problematic. And I want to contextualize this, though. There is this growing movement of understanding all women as potentially pregnant. In 1977, women were banned from participating in clinical trials because of potential harm to potential fetuses. That was overturned in '93 when we realized, oh, maybe we should look at gender when we're doing these types of studies. But this idea of all women, and we're here talking about cis women, as potentially harming potential fetuses continues today. Just last year, the WHO issued a statement saying pregnant women and women of childbearing age should not drink. They walked back a little bit on that to say, no, we're not saying all women age, 11 to 50. But there is this idea of the 0 trimester, that women are constantly in a state of pre-pregnancy. And we see this with iPledge, which is for anyone who's taking the prescription Accutane, which is an anti-acne medication. Here, every month, you have to get pregnancy tested. You have to prove that you're on 2 methods of contraception, and they have to be methods that meet certain standards. And this is regardless of whether you're a lesbian woman, whether you're not sexually active, whether you are a nun, whether you're on an ICU, or where you're probably not likely to be sexually active. But the potential harm to potential fetuses that this drug can cause, since it is teratogenic, is so great that we regulate it to this extent. And so I present this sort of to contextualize this background where if women are supposed to be seen as constantly pre-pregnant, some are saying, well, the 6-week limit shouldn't matter. It should always be trying to prevent harm to future fetuses. So there are limited exceptions, as was already talked about, no exception for rape and incest, which we think, many think is highly problematic given the trauma associated with those types of events. But there's also trauma associated with any type of unintended pregnancy if it's unwanted, and confusion over health exceptions, as Claire so nicely spoke about there. And then this idea of bounty hunters. And I put up the definition here of bounty hunters just to drive home this point that bounty hunters are looking for criminals. And so we have now labeled women who seek abortion and anyone who assists in any capacity as criminals. And so I just want that to sink in for a second. We don't have bounty hunters for any other medical practice that I'm aware of. So we have really elevated this to a point that we think it's so significant that we need to deputize everyday lay citizens to go out and bring criminals into justice. Another effect of this, again, that was talked about a little bit is reproductive tourism. And this cartoon here is actually about Alabama, but the same thing applies here, is women are left with the choice of, do they stay in Texas or do they leave the state? And for some women, this may not affect them too dramatically because they have money, they have the resources, they have PTO so they can leave and get an abortion. But this is going to disproportionately negatively affect already marginalized and underserved folks. Poor women, rural women, women with disabilities, and people of color. So we're just reinforcing this cycle where we're harming these folks who need our help the most. So let's now turn to abortion rhetoric. We see that the language of abortion is constantly growing and evolving. And we see this language of no forced birth really coming into more prominence more recently. This idea that there's forced pregnancy. And as we're going to talk about, a lot of this language draws on emotion because that's how it brings us into it. And the idea of forced pregnancy does draw on that emotion, as does the language of trust women, right? Fetal heartbeat as also same thing. But these culture wars are really dependent upon key language that has cultural currency that resonates with us on an emotional level to get us to side with that position. So I want to break down the different places where we have these dialogues. So one is just everyday lay conversation. And as you can see from this cartoon here, for wanted pregnancies, if you're talking to your friend who's pregnant, you're not going to say, hey, how's your embryo doing? Or have you felt your fetus yet today, right? That's not how we talk on an everyday level. We use terms like baby and mother, and this makes sense in our relationships with people we know who have wanted pregnancies. We give this social and emotional currency to that because we know that that's the contextualization of that pregnancy and of that relationship. That's different than medical terms, right? And so if we don't know how someone feels about it, we should defer to medical terms like fetus, pregnant person, termination. And we want to do this because we don't want to label someone with emotionally or social terms when that person may be seeking a termination, right? And we don't want to assign certain moral status to that pregnancy that the person may not agree with. And so whenever I'm working with medical students or OBGYNs or anyone working in the field, I say, I think it's best to start with these medical terms and then mirror whatever the patient is using. If the patient is referring to this as a baby, then you can mirror that language, but don't give that moral status based on your own view. And if you haven't seen this really funny clip from Amy Schumer, it just shows how awkward it is when healthcare professionals use non-medical terms. Her gynecologist is not comfortable using the word vagina or vulva, so is constantly referring to her anatomy by the word pussy. And it's just really hilarious. So I wanted to make sure I inserted some humor into this talk, because I know we're talking about heavy things, but also just to show how absurd it can be when we're using lay terms in medical settings. I want to point out that just because they're medical terms doesn't mean that they're objective or that they're neutral in any way, and that these terms have often been used to discredit women or belittle women. We have language like incompetent cervix or lazy ovary, geriatric pregnancy, right? These terms are clearly value-laden and are not neutral. So medical terms are not necessarily more neutral. And I think we need to continue to work to make medical terms not have these negative connotations, especially regarding reproductive and women's health. In public conversations, the language we use signals our values, right? What do we say is being ended through abortion? Do we say we're ending a life? Do we say we're ending a pregnancy? It really matters. And so sometimes we can't get to the substance of what the ethical values at play here because we get so caught up on the language. And I was lucky enough to collaborate with Claire Horner on a project talking about this, talking about abortifacients and how different groups define that term differently. And so they end up talking past each other because they're so hung up on how they're defining that term that they can't actually get to the meat of the argument to really understand where they disagree. So we like to think of the law as impartial, right? As neutral, that justice is blind. But what we see is that a lot of these anti-abortion laws are not impartial and that they are implying fetal personhood. And I want to give you some examples here to show this. So in some of these laws, there is non-medical terminology used, not just in laws, but also in policy. So something like late-term abortion. If you are a clinician and you're talking about late term, you're talking about after 39 weeks. You're talking about past, the normal due date. So we don't do abortions at 40 or 41 weeks. It doesn't make any sense. But this term, late-term abortion, is often used for abortions occurring after 21 weeks because it makes it sound like it's really far along, right? And that brings all the values with it that this shouldn't be happening because it's so late in the pregnancy. Or language like born alive again abortion or partial birth abortion. These refer to medical terms, but this is not the term if you go to medical school that they're going to be using. They're not going to call this partial birth abortion. But partial birth abortion as a term has a visceral reaction from us, right? And it gets us on board saying, well, who would want to support that? And that's the goal of some of this language on both sides. Again, pulling on our heartstrings to make us feel a certain way. So let's look at some of the abortion laws that were proposed in 2019. And I have the ones in red here that are laws trying to restrict abortion, and the ones in green, laws that are trying to protect abortion. And you can see the very value-laden language that's being used in these restrictive laws. Human life protection, the Cherish Act, Dismemberment Abortion Act, right? Unborn, detectable heartbeat, right? These are very emotive terms that are being used. The laws that are trying to protect abortion also draw on some emotion, but I think they do less so. It's things like authorize certain healthcare professionals to provide abortion, to perform abortion, remove obstacles and expand abortion. Trust Nevada, that has some emotive connotations there. Act relating to preserving the right to abortion. Again, not as strong of emotional language here. And what we can see from this really interesting study that was done is look at the language that is more common in each of these types of bills. So in bills that are more restrictive, we see very strong emotional language here. And all this language is from the perspective of the fetus. So we're saying things like violation, death, injury, and abuse of the fetus. Very, very strong language. Whereas the laws that are trying to protect abortion are from the perspective of the pregnant person. And they're talking about the pregnant person's rights and benefits and respect. So they also bring up connotations here, but I don't think they draw on the emotional language to the same degree. That's my personal opinion. Again, you can disagree with that. We can talk about that in the Q&A. So I want to get to how language impacts personhood. And personhood is, I'm a philosopher, we often use this in a very philosophical sense, but in a lay sense, or even legally speaking, someone is a person if they have the right to have certain rights. So a person needs to be treated a certain way. We can't, do certain things to a person. So who counts as a person? Well, it's changed over time, and not all people that we would consider today have had those rights. So in the US, yes, white dudes have had it since the beginning of the country, but people of color and women have not, right? Just kidding, women got it in 1971. But we also see here that corporations are now considered legal persons, and so are certain animals. And so I have this quote here that's showing that this is highly contingent. It's contingent on the cultural context, on the cultural and religious and philosophical values of a given society. And as this person says here, it's both a site of and the source of ongoing cultural contests. And it's always under construction as self-evident fact of nature. And we see this in the abortion dialogue, where people are saying, well, obviously a fetus is a person. And other people saying, no, clearly the fetus is not a person. Both sides see this as obvious when they're clearly disagreeing here. So what are some criteria that are often used to discuss personhood, at least from an ethics perspective? I want to run through 5 of these and show how abortion laws tie into this. So cognitive abilities is one. And we often think what makes us as humans special is our intellectual abilities, that we have this amazing brain that can do all these things that other animals' brains cannot do. And this is from an article from New England Journal of Medicine going back a few decades. But what this author is saying is that when it became possible to replace both cardiac and pulmonary functions with medicine, we couldn't define death anymore as the cessation of cardiac and pulmonary functions. We needed to turn to something else. And so we turned to the only unique and irreplaceable organ, the brain. And so this person says the presence of a functioning human brain means that we have a person. And this is now the medical definition of human life. And so if we consider this framework, what we see is that brain function, depending on how you measure it, can appear in the fetus about 8 weeks. And so this argument we sometimes see come along to justify bans on abortion after 8 weeks, saying, well, the brain is there. And so, this is just the same as anyone else. Obviously, we can talk about some differences there, but this is one perspective. I mean, the brain function in an 8-week-old fetus, I think we could argue is quite different than that of a 40-year-old adult or that of a 4-week-old infant, right? It varies, cognitive abilities vary depending on age and also all sorts of other factors. Relationships is another one here. And so some people say, well, look, the pregnant person is genetically related or is carrying this embryo fetus, therefore they have certain obligations to the fetus. And this rests, though, on this idea that essentializes the relationship between the pregnant person and the child and the fetus. And this quote is from Gonzalez versus Carhart, which was the Supreme Court ruling that upheld the Partial Birth Abortion Act. And they, in this law, said respect for human life finds an ultimate expression in the bond of love the mother has for her child. So packed in here is this idea that a pregnant person should act a certain way towards the fetus because of this essential and inherent love that all pregnant people and all mothers have towards fetuses and children. And some people say, well, look, there's scientific evidence that there's a bond here, that fetuses respond more to intended parents' touch and voice. And what we see, though, and this was a really interesting study that a colleague of mine at the University of Albany did, Elise Zendaya, is we asked abortion providers, well, who should be determining the moral status of the fetus and whether it has personhood or whatnot? And what we found is abortion providers, and actually also neonatologists, who we also interviewed, said it's context dependent. It depends on what the pregnant person says to us. And so I have these 2 quotes here that are just so rich from these folks who say, if the patient is on labor and delivery and says, this is my baby, save my baby. Okay, we save the baby. The fetus now has moral status because the pregnant person gave it to them. But if the person is coming in for a termination, we say, okay, that's the moral status you have assigned. So I just mirror whatever the status they're applying here. So here again is this idea of this approach being relational, but being based on and conferred by the pregnant woman. And this is what we see in some of the feminist literature as well, that given the intimacy of pregnancy, we should allow pregnant women to determine the moral status of the fetus. Moral agency is another factor that sometimes people use for personhood. And moral agency means the ability to determine right from wrong. And as you can see from this picture of the two toddlers fighting over a drink here, toddlers and children and maybe some adults don't have that ability to determine right from wrong. But some people say, well, we don't need to focus on the agency, the moral agency part. Let's just focus on the agency part, acting intentionally. And when we interviewed these providers, what we found is they were distinguishing between, well, what's really reflex and what's really acting intentionally. Because babies and fetuses may do things, but it may just be reflex. And so I want to move on to sentience, which is the ability to feel pain and pleasure, and combine it with agency to show you this quote from a Texas congressman about a decade ago, who was saying that fetuses are making purposeful movements. Look at them, they stroke their face. If they're a male baby, they may have their hand between their legs. If they feel pleasure, why is it so hard to believe they could feel pain? So that fetuses are masturbating, and therefore that's signaling that they not only have intentional action, but that they also can feel pain. And this idea of sentience has been used a lot to claim that we should ban abortions after 20 weeks. And this silent scream is a documentary that's from the victim's point of view, showing this fetus apparently screaming. What we see is that there's consensus in the medical literature that pain is not possible until about 26 to 29 weeks gestation. But this idea of fetal pain has been used on the federal level and also on the state level to ban abortion in 17 states, including Texas. So I want to wrap up with the idea of human properties, because that's what's going on with this fetal heartbeat law. And human properties is that, the fetus is like us. Perhaps they have human DNA, or they have symbolic organs. And this is a picture here from the movie Juno, where she's going to get an abortion, and there's an anti-abortion activist in the parking lot who says, your baby probably has a beating heart, and it has fingernails. And this idea of fingernails is actually what influences her not to get an abortion. And people know that these organs have symbolic value, right? The author of SB8 says the heartbeat is the universal sign of life. And that's why we have called this a heartbeat bill. We don't call it the cardiac activity bill because it wouldn't have the same emotional weight. So even though a 6-week embryo doesn't have a developed heart, again, a heartbeat bill brings up a different image at play. And so just to wrap up here, these heartbeat laws are one of the latest rhetorical strategies for assigning fetal personhood based on this idea that fetuses are like us, they have human properties. The other thing that the heartbeat law does that also these fetal pain laws do is that they appeal to people on a scientific level. It's like, this is measurable, this is scientific. It's no longer just a philosopher's question of when does life begin. We can now have certain measurable objectives. And the symbolism pulls on our heartstrings, right? So I will end there. Thank you so much.
Lisa, thank you so very much. We learned so much, and clearly the power of words, and some might say, sad to say, marketing as well, as we further explore this. And thank you. Just a reminder, we will be taking questions. I know we've got a few in the queue. We'll open that up fully for answers after our next speaker. And I'm delighted to introduce you to Rajani Bhatia, an associate professor of women's, gender, and sexuality studies at the University at Albany. Bhatia's research focuses on reproductive technologies, health, bioethics, and biomedicine. Through engagement as a scholar activist within international and national women's health and reproductive justice movements, Dr. Bhatia contributed to feminist analysis of global population control, right-wing environmentalism, coercive practices, and unethical testing related to contraceptive and sterilization technologies, both inside and outside the US. Batya is author of Gender Before Birth, Sex Selection in a Transnational Context, and that was with the University of Washington Press. Rajani Batya, please, it's my pleasure to welcome you. And as I've been saying, the screen is yours.
Thank you, Benita. I also want to thank Shelley Calabrese of the Women's Institute of Russell Sage College and my co-panelists for this opportunity to engage an incredibly timely topic. I'd also like to acknowledge Marisa Pizzi from Collective Power for Reproductive Justice, or RJ, who indulged me by meeting to brainstorm for this panel. Today, I am speaking as an RJ Scholar activist. It is my task to address the social implications of SB 8. As you know, one of the most insidious aspects of the law is that it deputizes regular people, not public officials, to enforce it. Private individuals can bring lawsuits against anyone found to aid or abet a procedure performed after 6 weeks, which could include someone who drives a patient to a clinic or who provides financial assistance. Incentivizing vigilante interference, successful lawsuits will be awarded with what many have called a bounty of $10,000 plus legal fees. As Farah Diaz-Tello, Senior Counsel and Legal Director for If, When, How, a national RJ nonprofit, describes, the law cuts people off from systems of care by criminalizing other people who might support them. The people who end up getting swept up in criminalization are loved ones. It's somebody's mother, it's somebody's sister, it's somebody's friends who provided them with the means to end their pregnancy. They're right in the crosshairs of this law. That's not a bug, that's a feature. Making people afraid to seek help from loved ones because they think their loved ones might be susceptible to criminalization. Isn't that exactly what this law is intended to do? Barely 5 years after the Supreme Court in the 2016 Whole Women's Health versus Hellerstadt decision struck down Texas TRAP laws that imposed unconstitutional restrictions related to building structures and clinician hospital admitting privileges, the new Texas law uses a social mechanism to instill fear and suspicion among individuals that attempts to strike at communities and social networks. In combination with the Supreme Court's recent deliberation over the Mississippi law banning abortions after 15 weeks of pregnancy, the discourse among activists concerned with securing safe, legal, and accessible abortion has increasingly shifted to planning for the end of Roe. As inconceivable and bleak as this may seem, I am going to paint a picture that is less dystopic and more hopeful than the Handmaid's Tale rhetoric and visuals accompanying this moment. The reality is that we have been preparing for this quite some time. Through the strength of our social networks, mutual aid, transnational solidarity, and the focusing of a reproductive justice lens that has allowed us to see and make meaningful connections to related issues of concern, we are facing this challenge with considerable social strength and resolve that cannot be so easily broken. Sorry. The achievement of legalized abortion in the US in 1973 came via the Supreme Court decision in Roe as a negative right of government non-interference to protect the privacy of individuals. Yet the apparent universality of such a right was easily contradicted through a political reality for some groups, particularly poor women on public assistance, who had neither privacy nor the means to enact it. On the heels of abortion's legalization in the US, the passage of the Hyde Amendment in 1976 assured that no federal monies could be used to finance abortion procedures for low-income women relying on publicly funded healthcare coverage. And many state governments followed suit, closing off all public financing options to cover abortion costs. In addition to financial inaccessibility, logistical access has been complicated for decades since the 1992 Supreme Court decision in Planned Parenthood versus Casey upheld Roe, but afforded states more authority in regulating abortion during the first trimester. The number and types of state legislation aimed at restricting abortion proliferated. They include mandating inaccurate counseling on the health impacts of abortion, the imposition of mandatory waiting periods, and parental consent laws, to more recent trap legislation that requires providers to have hospital admitting privileges and clinics to have ambulatory surgical facilities or locate a prescribed distance away from schools. The result has been an expansion of abortion deserts, clinic closures, and an increase in risks and costs due to delayed abortions. I want to emphasize here that we have been organizing in the context of these constraints for a very long time and have been quite busy building conceptual and practical infrastructures of resistance. Conceptually, the RJ movement, which calls for the right not to have children, the right to have children under the conditions we choose, and the right to parent the children we have in safe and healthy environments, is fiercely intersectional and recognizes histories of reproductive oppression faced by BIPOC communities. RJ perspectives interpret these latest assaults on abortion access as interconnected with other means of controlling poor or BIPOC cis women, trans, and non-binary people. For this reason, resistance to the Texas law has quickly expanded across coalitions, eliciting support and mutual aid. Take, for example, Black Lives Matter. Apart from the ways that the law's enforcement mechanism unambiguously intimates white supremacists mobilizing via stand your ground laws and anti-immigrant vigilante border enforcement to police and criminalize Black and brown bodies, as well as fugitive slave acts of past, connections are being made to broader healthcare inequities in the state, which lead to higher rates of HIV and unintended pregnancy among Black and brown communities, but also disparities in maternal and infant health outcomes. Black Lives Matter via hashtag All Hands on Deck Texas raised funds for the AFIA Center, one among 13 organizations in the Trust, Respect, Access Coalition, which shares a commitment to anti-racism. Social justice activists working across multiple movements understand political coordination by conservative political forces links Texas anti-abortion laws to the recent slew of anti-critical race theory teaching and anti-trans youth laws that limit transgender youth's access to bathrooms and sports in their schools and gender-affirming care. Often, the architects of these laws are the very same people. In an amicus brief dated July 29, 2021, urging SCOTUS to overturn Roe, for example, former Texas Solicitor General and Texas Right to Life member Jonathan Mitchell also suggested the judges consider recriminalizing sodomy and outlawing same-sex marriage. Then, of course, is the direct impact of clinic closures, which have provided a rare source of LGBTQ sensitive and gender-affirming healthcare for trans and non-binary people. The point here is that the intersectional analysis at the heart of RJ has provided a platform for coalition building because it promotes understanding of reproductive oppressions in connection with other oppressions faced by marginalized communities. The All Above All coalition of 130 partners, which launched in 2013 to restore public funding of abortions, is a case in point. They state on their website, abortion restrictions fall hardest on people unable to make ends meet and others marginalized by our healthcare systems, especially people of color, immigrants, transgender people, and young people. We're done with lawmakers interfering in our personal decisions. They have campaigns on abortion, economic, and immigrant justice, and partnered with One Fair Wage to support and pass a $15 per hour minimum wage increase in DC. Meanwhile, this type of cross-issue organizing is reflected in recent resistance to the Texas abortion law, also among the increasingly youthful membership of the Democratic Socialists of America, who have advocated for Defend Roe working groups in each chapter. So RJ movements have impacted both the theory and praxis around abortion politics. Although at the time of the initial conceptualization of reproductive justice in the mid-1990s, the movement challenged a reproductive rights framework that had become libertarian, abortion-centric, and focused on market-driven notions of choice. The importance of safe, legal, and accessible abortion was never lost in justice-oriented frameworks. In response to SB 8, RJ activists increasingly embrace explicitly naming abortion in recent struggles. In the October 2nd RJ rallies organized across the United States, we saw signs increasingly calling for abortion justice, liberate abortion, and abortion is healthcare, along with bans off our bodies. There was also an emphasis on abortion as a bodily autonomy issue and not exclusively a woman's issue. Another trend is the increasing invocation of transnational symbols, such as the kerchief, often in the color green, that is borrowed from what is known as the Marea Verde, or green wave of organizing by feminists in Latin America. The green kerchief is itself originated in Argentina in a national campaign for legal, safe, and free abortion that successfully led the country to legalize abortion upon demand with full public health insurance coverage up to 14 weeks in gestation. And I think that's worth repeating. Argentina has legalized abortion upon demand with full public health insurance coverage up to 14 weeks. The symbolic kerchief, as well as this model of organizing, was taken up in Ecuador, Mexico, and Peru in a variety of feminist campaigns, but is most associated transnationally with movements to decriminalize abortion. Here we see demonstrators using an orange kerchief in their protests at the Texas Capitol, but we have also seen green kerchiefs that draw on the current strength of transnational activism, as in this image with the words "Hold the Line," put out by the Women's March to inspire activists not to yield to the unending pressure from highly coordinated anti-abortion forces. The fact that abortion was decriminalized in Mexico on September 13th, just days after SB 8 went into effect, has further compelled transnational solidarity, especially along the border, where severe restrictions around abortion access since 2013 in Texas had already prompted cross-border movements for self-managed abortion. On a practical level, resistance to Hyde formed through the establishment of grassroots abortion funds. Local funds from 14 states came together in 1993 to form the National Network of Abortion Funds, or NAF for short, which led efforts to shed light on punitive welfare reform, as well as the harm created by the Hyde Amendment in the 1990s. In 2010, NAF launched a 15-year plan to repeal Hyde, which became the campaign and coalition All Above All. In 2016, they facilitated collaboration of abortion funds in the South and created internal funds to help patients in Mississippi and Alabama. Since the Trump presidency, through regional and national convenings, they have worked to fortify pathways of support. Make no mistake, it is the strength of these networked organizations that has led to a law that seeks to specifically attack abortion funds, which provide both financial and logistical support. NAF has focused directing financial support to funds in the South or Midwest, or those that are experiencing an increase of callers traveling to a coverage area. In a statement on the Texas crisis dated September 7th, NAF wrote, quote, "As you read this, funds and clinics in Texas and across the network are collaborating, rushing to support callers to rebook appointments and coordinate out-of-state trips with distances up to 20 times longer. Abortion funds have the expertise and connections to assist callers as they navigate barriers that have increased exponentially." NAF has more than doubled its staff of regional case managers since 2020. Abortion funds and allied groups also provide practical support, such as transportation, childcare, lodging, translation, escorts, or abortion doulas. Access Reproductive Care Southeast, for example, services 6 states: Georgia, Florida, Alabama, South Carolina, Tennessee, and Mississippi, providing and facilitating such support. The Bridget Alliance, named after an Irish patron saint whose miracle was to perform an abortion for a nun, formed in 2018 to assist individuals needing to travel for later abortion care. According to the director, knowing that, quote, people were sleeping in cars, cashing in their savings, skipping their rent or meals to cover travel expenses, the Alliance established a range of services, including, again in her words, booking and coordinating lodging, arranging transportation like flights, bus tickets, train tickets, sending cash to cover gas, tolls, and parking, arranging ride shares, sending gift certificates to cover rides or cabs. We provide meal stipends and childcare reimbursements as well. We also coordinate with a few fantastic on-the-ground volunteer-based organizations that exist across the country who provide overnight hosting, meal support, rides, and escorts. While legal abortions in Texas declined by 50% in the first month under SB 8, they have increased in Oklahoma, Louisiana, New Mexico, and Arkansas, where Texans have traveled seeking them. Now that SB 8 necessitates travel after only 6 weeks, a number of funds, some new and others more established, have been working hard to ensure access across state lines. I'm going to put a highlight on Jane's Due Process, which is a fund that formed in 2001 when Texas passed a parental notification law for minors. The organization helps teens secure judicial bypass to avoid involving parents, and they organize to discreetly drop off repro kits with emergency contraception and pregnancy tests. They advise on the best places to take a pregnancy test. Your high school bathroom may be convenient, but Buc-ee's, which I guess is a convenience store, has stalls that reach the floor, affording privacy if you need to cry. Plus, they have a good snack selection. Jane's Due Process and other funds also train new generations of activists on how to fight for access in their communities and across state borders. Broadly, the RJ movement's focus on identification of abortion havens and facilitation of cross-state border access has obviously intensified as upwards of 20 states have trigger laws in place to ban abortion should Roe be overturned. California state legislators and Governor Newsom recently announced the intention of the state to become a sanctuary with an allocation of public funds to assist those who must travel there to access an abortion. Texans are also increasingly taking a cue from international activism, where autonomous health movements created hotlines and forms of accompaniment to assist individuals in accessing medication abortion where it is illegal. Of course, medication abortion was approved by the FDA in 2000 as a regimen consisting of 2 drugs for use up to 10 weeks gestation. This non-surgical option now makes up over 40% of all abortions in the country. Although the FDA strictly regulates one of the 2 drugs, compelling individuals to obtain it directly in person from a certified provider, the pandemic changed that on a temporary basis. And then on December 16th, the FDA permanently lifted the in-person requirement. So medication abortion can now be obtained in the mail after a telemedicine appointment with a certified provider, obviating the need for clinics altogether in the case of early pregnancies. Online startups like Hey Jane and Abortion on Demand have already sprung up to provide this service to anyone where it is legal. Not surprisingly, Texas banned the mailing of abortion pills soon after SB 8, but Aid Access, a nonprofit based in Europe, is prescribing it to those with pregnancies past 6 weeks and before 10, and the pills are mailed from a pharmacy in India. Meanwhile, in Latin America, provision of self-managed abortions relied on only one of the 2 drugs, misoprostol, which has been found to be just as effective at ending pregnancies up to 9 weeks gestation as clinical abortions, according to a recent Lancet article studying self-managed abortions in Argentina and Nigeria. As a common ulcer medication, it is inexpensive and less regulated. I underline here that medication abortion is as much a social as a medical technology, which operates via hotlines and civil disobedience networks. These networks match those in need of an abortion with someone who will accompany them through the process via telephone or video calls and WhatsApp messaging. They organize in many cases for men to pick up the pills from pharmacies to avoid scrutiny and questioning. These networks sprung up along and across the Texas border to Mexico much before SB 8, and they continue to operate. They are part of a long tradition of self-managed abortions in health activism. Finally, strong resistance has arisen to thwart the private enforcement aspect of SB 8. When Texas Right to Life, the state's largest anti-choice organization, set up the website ProLifeWhistleblower.com with an online form to submit tips on any potential offenders, it was immediately flooded with bogus tips from hacktivists on TikTok, Twitter, and Reddit. In conclusion, I do not want to minimize the negative social consequences of SB 8, nor of losing Roe. Yet it is important to highlight the strength of decades of autonomous social and reproductive justice activism, networking, and collaborative effort that has gone into ensuring abortion access for many, despite constant obstacles raised by state institutions. Yet we must acknowledge the current situation is not sustainable. RJ movements have long envisioned even better legal frameworks than Roe, which would refuse to compromise access in the quest to maintain legal abortions. In this bleak moment, let's keep our eyes on that vision and be inspired by feminist struggles in other countries that have shown it can be done. Support landmark bills before the US Congress, WIPA, that will protect the right to access abortion care free from restrictions and bans, each which will reverse the Hyde Amendment and expand insurance coverage for abortion care, HEAL, which removes barriers to healthcare for immigrants of all statuses, and Rosie's Law in Texas, which would restore health insurance coverage of abortion for Texans, as well as any grassroots abortion fund in that state or across the nation. Thank you.
Thank you so much to all of our panelists tonight. We're going to go ahead and get started with questions. We have, what can individuals or even small groups, think book clubs or hobby groups, do to support women affected by SB 8? Living in this area with many liberal politicians, I wonder how we can reach out and provide support.
I know Rajani just talked about a whole lot of Texas groups and other grassroots movements that are really helpful. But something a little bit different that I'll suggest, especially in Texas, is to encourage, if you know clinicians, to encourage them to testify for different legislation, because especially for a lot of these bioethics related laws, oftentimes the perspectives of the medical community are not represented because they're not the ones who have several lobbyists and activists going and testifying before the legislators. And so I know that they've asked for that a lot, to have clinicians and people who are impacted by these to go and testify themselves.
Thank you very much. We've got a question: what can individuals or even small groups, think book clubs or hobby groups, do to support women affected by SB 8? Living in this area with many liberal politicians, I wonder how we can reach out and provide support. Open to our panelists.
Sorry, Benita, I jumped in when there was I think there was a lag in the technology there. So I already asked that question. So you can go ahead and move on to the next one.
I apologize. We really did.
If I just could, sorry, to that question, just reiterate that there are a number of Texas abortion funds that one could support. And then, so there's a whole list of them, which I'm happy to bring up if anyone is interested. But that would be an amazing way, but also within our own states to ensure that should we lose Roe, that we work towards making our state a haven or a sanctuary for those who are in need of abortions.
See, there was a method to the madness. And I'm going to ask another question that ties into the answer, Rajani, you just shared. What happens if Roe v. Wade is overturned? Will we see laws like Texas, SB 8 in New York, or other states?
Yeah, I think at least 26 states are poised to completely ban abortion if Roe v. Wade is overturned. So essentially what happens if that is overturned, it goes back to the states, and each state is free to make their own laws related to abortion. So over half the states right now either have or have already declared that they will pass laws. So many of the states, including Texas, already have laws passed and on the books, just waiting for Roe v. Wade to be overturned.
Thank you. And I should point out also, if any one of the other panelists want to jump in with an answer, please go right ahead. And I'm just going to move on to the next question. How does this bill go against a person's Ninth Amendment right, if it does?
I defer to the lawyer on that one.
Claire?
Sorry, I'm having some technical difficulties. Trying to remember my Ninth Amendment now.
Quick, we have to Google, right?
We do. The idea that the people retain rights, the federalism argument, I think that is, I mean, that's essentially the issue, right? It's whether or not the federal government has the right to make those decisions, or if the people and the states have the right to make those laws. So it really is exactly that. And that's what's been fought over for years with privacy.
Mm-hmm. Now, another question is, if this bill is passed, do you think it will be adopted to include rape and incest as an exception to the law?
SB 8 has actually already been passed. So no, it doesn't include rape and incest.
Mm-hmm. And perhaps, I think maybe the questioner really meant, it's passed if it survives the challenges and then has to be rewritten. I can freelance a little there. Does it stand the way it is? Because it's probably going to find its way to the Supreme Court, which of course becomes a conversation for us to have another session here.
Right. Yeah, I think what makes it unique is that it's not about state action. So unless they can make a novel argument that it actually is state action, which I think there is something there to say, if you have a judge enforce an action like this, there is some level of state action. Without that, though, the rape and incest laws that have been upheld, or portions of the law that have been upheld, I think there's a question as to whether or not that would have to be included, but it's definitely unprecedented.
Yeah. I know you're not going to list it, but somebody wants to know about the 26 states that are set to make abortions illegal if Roe v. Wade is overturned. Where is a list? Where can one find a list easily?
I believe the Center for Reproductive Rights has a website that has a lot of that data on it. There's lots of places, though, that you can get that. Google is the best friend for that, but Center for Reproductive Rights would probably be my first stop.
And I would just mention the Guttmacher Institute as well.
Thank you. Thank you very much. I see that the importance of language in how we define legally, ethically, socially, personhood and medical emergency. How do we define women's rights and choice? Are there legal, ethical definitions of these words that can help in protecting abortion?
Yeah, so I mean, I think we talk about autonomy rights, and negative rights are sacrosanct in medical world. The idea that no one can infringe on your body without you saying so. However, we have historically made exceptions for that for pregnant folks, but there is legal precedent. Shimfi McFall was a case where a cousin took his cousin to court wanting a bone marrow transplant that would save his life. And the court argued quite strongly that we're not going to allow you to suck at the jugular of another, even if it means this person is going to die otherwise. So this idea of individual autonomy, bodily integrity, these are the terms we use. But given our pronatalist, sexist society, we make exceptions for that when it comes to pregnant folks.
Thank you. And I'm going to, Lisa, keep you up for a moment. I think this next question is your bailiwick. Can you not argue that based on science, that the fetus is technically an obligate parasite that cannot be considered as equivalent to an independent person?
Sure. I mean, and that's what makes pregnancy so unique. I mean, besides something like conjoined twins, we don't have many situations in which one person is dependent upon or lives inside the body of the other. And so that's an argument that people often make is, no, the person on the outside whose house it is should be able to make those types of decisions. But that's not always going to be convincing for folks who believe that a fetus is a person, right? And so I would recommend Judith Jarvis Thompson's classic abortion article, where she makes this comparison. And she says, imagine one morning you wake up and you're connected to a famous violinist. Do you have the right to unhook yourself, knowing that that violinist is going to die and you're the only person who matches their blood type? And the argument there is that violinist is a person, right? They're a successful person. Maybe they're your sister, I don't know, but you still have the right to unplug yourself. So I think when we're making arguments about personhood, that's not going to be as fruitful because there's just so many folks who have different values about what the moral status is of the fetus. And that's not something that I don't think we can ever come to terms on, but we can make arguments that can be secular and appeal to all about bodily autonomy.
Lisa, thank you. The violinist, one of the hallmark lessons one learns in bioethics. Another question, when a fetus dies within the mother, I'm very concerned about the health issues of women who face miscarriage. I've read practitioners' reports that detail the grave issues of miscarriage versus anti-abortion laws. There's a question sort of wrapped in there someplace if you want to address the issue.
I mean, I can jump in if you want. We hear of horrible cases where there has been fetal demise, and yet no one is willing to do a procedure because the fetus is at a certain stage of gestation. Actually, something like this happened to my cousin, who was 8 months pregnant and had to stay pregnant for another month before they would induce her. And this is just so psychosocially traumatic, not just for the pregnant person, but her family, for the clinicians caring for her. And this, I think is a real problem that we may face as this law continues, especially if there is a weak fetal heartbeat as it goes on. And we saw the case in Ireland where a woman died and they wouldn't do an abortion because at the time abortion was illegal there because there was still a fetal heartbeat. And even though she was going into septic shock, they said, well, we can't do this. So, I think we really need to think through the repercussions of these laws. And as Claire said, this is why it's really important to hear the voices of clinicians who understand the nuts and bolts at the bedside, what's going on, and to hear the story of normal people, right? To normalize this, to say, hey, this happened to me or my cousin or to someone. So we realize this is not just abstract numbers. These are real people's lives.
But some might argue that they have thought this through, and this is the answer they have come to, those who have voted for SB 8. So that sort of brings us to another question one of the attendees has. And we know that Roe also helps protect your privacy. So the question this person has is it a possibility that politicians could be accepting donations from big companies that want your information or the information protected by this privacy clause, which is why they really want to overturn Roe? It's the times we live.
I'm not as concerned about the privacy specifically related to Roe. We have HIPAA, which protects health information, private health information. And certainly, so no matter what happens to Roe v. Wade, health information is still protected. However, politicians are accepting donations from large lobbying groups. For example, Texas Right to Life is one of the groups that my colleagues mentioned, it is the largest group in Texas that is really fighting for this law and laws like it. And they are big donors. So there is a lot of money that goes behind it, not necessarily trying to get private information from individuals, but definitely trying to get their own agendas on whatever side.
Yeah, so many things going on here, so much to contemplate. We've got a very nice thank you as well here, and I just want to see if we've got any more questions that didn't get answered. If the woman who undergoes the abortion isn't sued, wouldn't that just result in people getting more abortions, since it doesn't affect the person getting the abortion, but the abortions are outlawed? So
Well, they're technically not illegal, but anybody can be sued for helping a woman get an abortion. So you're right, the pregnant person does not get sued, but the doctor does, the nurse does, the person who pays for the pregnancy termination does, the partner or friend who encourages the pregnant person to get the abortion could be sued. So it definitely has a chilling effect because nobody's going to want to open themselves up to that liability.
which then ties into one more question. Will SB 8 allow the ability to sue those in other states or other countries that help women with regards to self-managed abortion?
I think that's a really good question. So there is an issue of jurisdiction, but I think it's an open question about whether or not a Texas resident could be sued for activity they do in other states, or somebody from out of state could be sued. In the United States, typically we don't sue when that happens, but there are definitely other countries like Australia that has they have laws about prosecuting individuals who go abroad and engage in gestational surrogacy, for example. So it's definitely not out of the realm of possibility, but I think that's another unanswered question.
Yeah, and then there was a very nice long message, but the question is, as long as wealthy people can have access to procedures, how is it possible preventing low-income or poor women be blocked?
Yeah, I mean, I think, Rajni, do you want to jump in on this one?
Yeah, I mean, so this is like nothing new. This is, as I mentioned, the Hyde Amendment has, was passed in 1976. And so this is part of this is not to deny that this is definitely reaching a whole nother level of restrictions that we need to work against. But yes, poor women have long been denied access to abortions. And I would just add, even though the law does not intend to criminalize the pregnant woman herself for trying to get an abortion, as you mentioned, Claire, it's technically still legal. I do worry about the implications for the pregnant women, any pregnant woman appearing before any kind of health facilities with a miscarriage, for example. We've had instances in the past where laws have at least openly intentioned, not to pursue any kind of criminalization of the pregnant women themselves, and then have ended up in actual cases where the woman is ended up being suspect for whatever reason in the clinical realm. So I do worry about like what will actually happen.
I want to thank you all so very, very much. Our thanks to Claire Horner, to Lisacampo Engelstein, to Rajani Bhatia, and to all of you for taking the time to take part in this, to ask such wonderful, thoughtful questions, to keep this conversation going. We've had a number of questions about providing this, the recording of this, and yes, it will be emailed to participants, so you will have the opportunity to review it and share it with others. So on behalf of the Sage Colleges, Shelley Calabrese, I want to thank you all so very much for taking part tonight. And Shelley, if you've got nothing else to jump in on, I guess I get the last word by saying thank you. Stay warm, stay well, everybody.